All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So I'm going to spend most of my time today talking about one particular case that I've talked about several times on the program here. It's a very significant case in the realm of discrimination law in the United States. It's a case that was argued before the U.S. Supreme Court yesterday, and it's also a case that comes out of St. Louis City. And so I think it's got particular relevance to all of the folks on the program here. So yesterday,
St. Louis is making the news again.
Yep, St. Louis is making the news again, and employers are going to face a potentially a lot more discrimination claims if the justices rule in accordance with the way they seem to be leaning yesterday during oral argument. So in this particular case yesterday, the justices appeared ready to widen or expand the anti-discrimination protection for workers in the U.S. during oral arguments in a case of Muldrow versus the city of St. Louis. They argued that the St. Louis police sergeant's fight to revive her sex discrimination suit over an unwanted departmental transfer, it seems that the justices are going to rule in her favor. Again, we don't know for sure, but just from the questioning. The justices yesterday spent nearly 2 hours in oral argument, which is quite a long time for one case before the U.S. Supreme Court. And they weighed really how courts should determine whether discriminatory workplace decisions cross the line into a violation of Title VII of the Civil Rights Act. In this case, the plaintiff's attorneys argued that the police officer, Muldrow, that she was stuck in a new role with less prestige and fewer responsibilities and perks because she's a woman, and that move violated Title VII. Now, mind you, she did not suffer any sort of wage decrease, but she really only suffered and I say only, but she suffered being stuck in a different role with less prestige.
That's interesting. Less prestige.
Yes.
Yeah.
And so the Eighth Circuit had found that the police officer's situation did not trigger the law's protections because her transfer did not surpass the standard in the Eighth Circuit of suffering a materially significant disadvantage. So that is a circuit-created standard. There are several circuits in the United States that honor that standard, but on the flip side, there are several circuits that don't have that standard. And so what some of the justices, kind of in a surprise alignment, you had Justice Gorsuch and Justice Kavanaugh and Justice Brown Jackson. They seemed of a mind to do away with that kind of additional harm requirement. And in particular, you had you had Justice Gorsuch saying that, quote, we've also kind of indicated in our cases that when you treat someone worse than another person because of race or sex, that's kind of the end of it. And there isn't a further inquiry into how badly you treated somebody worse. And so that really kind of marks a bold statement by one of the court's more significant conservative justices there. Gorsuch also said that adding a construct that we come up with that's artificial will weed out claims that Congress in 1964 thought profoundly important to include. Justice Kavanaugh, also another conservative justice on the court, further argued that treating someone differently based on race, for example, that in and of itself is the harm, and you don't really need to measure how much somebody was discriminated against. And so again, I think the significance here is that we're in a situation, it seems that the Eighth Circuit is poised, the Supreme Court is poised to do away with the Eighth Circuit standard of sort of a material harm, and any harm would be sufficient if the Supreme Court does away with that standard. What that means for employers is you really, really need to be careful because any sort of adverse employment action would, treating anyone differently based on the protected category, no matter how differently, can subject the employer to claims under the standard if that in fact becomes the standard.
Absolutely. That will be a revolutionary change in the concept of material.
Yes.
When you start talking about prestige, I don't even know how you measure the perception of prestige. That can be so individually perceived in that sense. That seems really complicated to me.
Well, I agree, and I think. Oh yeah, yeah. Thanks, Paige. That's exactly right. It's. I think the point here is that what the justices would be saying is that the courts should not function as a gatekeeper for determining what constitutes an adverse employment action. That's a question of fact for a jury to decide someday, whether the person truly was discriminated against and whether the prestige that they lost by the transfer really is some form of discrimination. So we'll wait and see how that shakes out. I will be sure to report back on the decision once that is issued, because it is a very significant case. I also happen to know, not very well, but I do happen to know one of the attorneys that argued on behalf of the city. She's in the City of St. Louis City Councilor's office, Shania Hamilton, and so it'll be interesting to see how that case shakes out.
You know, it would be great when it's all said and done to have her join the program.
I will maybe ask her, but my guess is we'll see what shakes out. Let me see how that shapes up, Phil.
Well, you can tell her she can join, or we're going to talk about her, one of the two. But Bert, any idea what was this person's role? What was the job?
I'm aware of that. So she had a job where she was a plainclothes officer in a prestigious investigative unit, and she was transferred to a position where she was in a uniformed role, in more of a beat cop, somebody who was actually on patrol, and she also, because of that, lost her. She was no longer able to wear plain clothes on assignment, and she had to get rid of her FBI credentials, turn in her FBI issued vehicle, and forego a regular Monday through Friday schedule for a rotating schedule with few weekends off. And so those were the decisions that departmental transfer led to.
Okay, yeah, interesting. That's starts to give us a little bit of insight. We look forward to hearing what the ruling of that will be. Any idea how long that would take, or is this something we'll know by next week?
No, we won't know next week. I would say anywhere from about 2 to 6 months.
Okay, well, that sounds like America to me. All right, there we go.
All right.
Okay.
So I talked about that one in detail. I know we've got a great guest on the program, and I think that's going to be the only one I'm going to cover today, trying to stick to my 8-10 minutes, something like that, but 6 minutes of lawyer on the clock.
You know, Bert, we're always happy to get a little extra time from you. And I think that's maybe the lesson for our listeners is if that's how you run your book of business there at Ogletree, I think the phone's going to start ringing for you. We'll take those 6 minutes any day.
Thank you.
But great job as always, Bert. That's a very interesting case for all of us to follow.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.